Welcome back to CBS Mornings. A man freed after more than 3 decades behind bars may soon learn if he can stay free. Crosley Green's conviction for murder was overturned back in 2018 by a federal court, and for the last 2 years, he has been a free man. But another court reinstated his conviction, and now he's asking the Supreme Court for help. If the justices decide not to hear this case, we may learn their decision tomorrow. He'll likely go back to prison. Erin Moriarty is her name. She's not changed it. She's been following Green's story for many years now. Erin, good morning to you. This is a stunning turn of events for Mr. Green.
Oh, it is. Good morning, Gayle. The odds are stacked against Crosley Green. The Supreme Court accepts very few cases for review. In the last term, out of almost 5,000 petitions filed, only 70 cases were argued. And it's not the facts of Green's case that justices will be looking at. It's whether the case presents a substantial federal legal issue that needs resolving by the highest court in the country. So here's how Green got to this point.
Since Crosley Green came home on conditional release in April 2021, the 65-year-old has savored joys that most people take for granted. Strawberry ice cream, a full-time job, and time with family.
It's good. Come on.
Green spent 32 years in prison, 19 of them on death row, for the murder of a young Florida man, Charles Chip Flynn. Flynn's former girlfriend, Kim Halleck, told police a black man robbed them and then shot 22-year-old Flynn. Halleck picked Green, a local small-time drug dealer, out of this photo lineup, although the citrus grove where the shooting occurred was pitch black.
I really didn't get a real good look at him. I was really scared.
There was no physical evidence tying Green to the crime, no fingerprints, no weapon, no blood. But Green was convicted by an all-white jury in 1990.
I didn't kill that young man.
Crosley Green always insisted he had nothing to do with the murder.
I kidnapped no one. I killed no one. I did none of those things.
And there was evidence to support his claim. When Brevard County Deputy Sheriff Mark Rixey and Sergeant Diane Clark arrived at the scene, Flynn was still alive.
First words out of his mouth were, "Get me out of here. I want to go home."
Did he mention anything about an assailant?
Nope. No. I'm thinking, what the hell is going on here?
Rixey and Clark even told the trial prosecutor of their concerns back then, and he took notes.
Mark and Diane suspect the girl did it. She changed her story a couple of times.
But the prosecutor, who believed Halleck was innocent of the crime, never turned over those notes to Green's defense team.
This is the evidence of innocence that was hidden by the prosecutor.
Keith Harrison is one of Crosley Green's attorneys. In 2018, a federal judge ruled that the notes should have been disclosed and overturned Green's conviction. But the state of Florida appealed that decision, and 3.5 years later, a court of appeals sided with the state. This court decided that the withheld notes would not have changed the verdict to trial and ruled that Green shouldn't even be in federal court because he failed to exhaust all his claims in state court first. But Crosley Green, ever the optimist, had this to say.
It may take more time for you sisters to get right, but it's going to get right eventually. You know?
And you still have faith that the system is going to get it right eventually?
Of course. I'm not going to give up my faith. You know what I'm saying? I came too far to give up my faith. I mean, look what my faith got me. Here again, with you, with my family, you know, with friends. All I do, I get up and I pray for another day.
Yeah, he's 65 years of age. He's not the only one who is hoping the Supreme Court takes this case. There have been a number of prosecutors, state court judges and professors who are asking the Supreme Court to review the case with these friends of the court briefs. And here's the big issue here. There's a concern that if in case this case stands, it waters down one of the most important protections for criminal defendants. And that's a requirement for the prosecutor to hand over that material exculpatory evidence. And in this case, remember, this was 1990 back in Florida. And Crosley's trial attorney wanted to say, I think the girl did it, but he didn't want to offend the jury. Imagine if he had those notes and he could have put on these two white first responders who would have been saying it.
Yeah. So it's almost like the evidence in support of Crosley Green doesn't matter at this point. It makes you think that you hope the Supreme Court has the evidence that you just showed us here to show the discrepancies.
But they won't be looking at that. They're going to be looking at.
Frustrating.
I know.
But they're looking at the important legal issue of whether then does this water down? Because it was a Supreme Court case that gave us this protection.
Yes.
It was the 1963 Brady versus Maryland. So whether the Supreme Court thinks that this waters it down too much, there's a number of different legal issues that
that's
the Supreme
system
Court.
talking about the system, where what everyone really cares about is did he do it or not?
Or not.
But
It appears not.
Yes.
I have been here so many times talking about that when you get to the appellate court, really innocence isn't the big issue.
It's deeper than that.
Crazy.
It's the legal issue.
And Erin, you're saying the Supreme Court rarely takes cases.
I know.
So
We'll
that's
know
why
Monday. Actually, I misspoke. It's next Monday. They will issue which cases they take and which ones they don't.
But the fact that he still has faith in the system says a lot about the hope that he clings to.
I
That's
know.
for sure. And,
and
thank you.
a lot about him.
A lot about him.
A lot about